What challenges are US cloud providers facing in the European Union, with US government, US court and US president?
One of the biggest problems we are seeing right now is the struggle between complying with US laws regarding government access and anti-terrorism in particular, and European data protection laws. European laws are getting stricter and stricter on protecting the privacy of EU citizens. On the other hand, the US has a different focus on privacy, as I explained before, and also wants to ensure that its anti-terrorism and anti-crime efforts will have great success. And this has been expressed in particular in the so-called safe harbor and later privacy shield situation. For over a decade we had the safe harbor arrangement between the EU and the US, where European companies were permitted to do business with US companies dealing with personal data on the basis of self-certification. So the US company would say, I voluntarily comply with the European data protection law. That has been declared illegal, that arrangement, because there were no safeguards in practice that these US companies would actually comply with European laws. And that in turn had to do with the fact that organizations such as the FBI or the NSA had broad powers to access data stored in the US. So the European Court of Justice declared that a violation of human rights. European companies could not do business with that. A replacement was created in the form of the so-called privacy shield a while ago, which introduced some safeguards and some promises from the US government saying we will respect European law for European citizens. So if companies in the US want to do business involving European personal data, you can rest assured that that will work out well. But if you look carefully, there are places where exceptions are possible, like if national security is involved, which in my opinion is quickly the case for US government authorities. So that is a big problem.